Hello, and welcome to PubK's 2023 Government Contracts Annual Review. We're thrilled to have almost 4,000 people register for this annual review. On this day 3, we have already held 8 different sessions, with one more this afternoon after this, plus 2 more tomorrow. We hope you'll be able to join us for the remaining sessions, but a separate registration is required for each session that you want to attend. You can register on the PubK site. My name is Alan Schwatkin. I'm the president of the PubK Group and a partner in the law firm Nichols Lew. I'll be your host, facilitator, and moderator for this year's annual review. The PubK Group publishes 4 newsletters: PubK Law, PubK Compliance, PubK Cyber, and our newest, launched in mid-2022, PubK M&A. Many of you are already subscribers to one or more of these publications, and we very much appreciate your support. Some of you who are joining this annual review are not yet subscribers, but I hope you'll consider becoming a subscriber. Information is at the website shown on the slide or is available from any of the contacts you have at the PubK Group. This conference would not have been possible without the strong support of our event sponsors, all of whom are listed on these next 2 slides. I encourage you to look at the skills and capabilities these firms have and engage them accordingly. Also new in 2022, PubK joined with Arnold & Porter to launch a periodic podcast called Bonafide Needs, covering emerging issues and interesting interviews. We'll continue that podcast in 2023 as well, and encourage you to access them through our website. If you're interested in partnering with PubK on a podcast, we'd be pleased to discuss this opportunity with you. In lieu of speaker gifts and in honor of our sponsors, PubK is making a contribution to the Capital Area Food Bank. I hope you'll consider making an individual or an organizational contribution. Since this entire program is being held virtually, all attendees will be at listen-only mode. Your video will remain disabled throughout the session. But we welcome your questions. Use the Q&A box at the bottom of your screen. However, with so many attendees, it will not be possible to answer all of the questions in real time. We are capturing your questions and will endeavor to answer as many as possible after the conclusion of the annual review. Presentation slides for this session are now available on the PubK website, and all presentation slides, along with the audios, will be available for download from the PubK site, probably within a week or so of the conclusion of the full annual review. We'll send an email when this information is available for download, how to access it, and for how long the material will be available. We are also applying for continuing legal education approval in Virginia, California, Texas, Florida, Colorado, and Kansas. We've already received approval from Florida, but while we cannot guarantee approval from the other jurisdictions, we do expect that acceptance within the next few weeks. Again, we'll notify all attendees who have requested CLE approval when those approvals have been received. So if you're interested in obtaining CLE, please look for our poll question during this presentation. The state boards require us to verify your participation during the event. We'll keep track of responses to verify that you viewed the panel. If you don't wish to obtain CLE credit, you can disregard the poll or just answer for fun. Now, I'm thrilled to continue this 8th PubK annual review with our Session 9 panel on small business contracting. Our distinguished panel members include Sam Lee, formerly the Assistant General Counsel at SBA and now the Director of Policy, Planning, and Liaison in the Office of Government Contracting at SBA, Matt Carter of Pillsbury, and David Black at Holland & Knight. Sam, over to you.
Thanks so much, Alan. Thanks to PubK Law for having me back for the small business panel. Thanks to Bill Oliver for running the slides and putting everything together. I'm Sam Lee. I'm the policy director at SBA, and we had a very busy year in 2022 over at SBA. We touched our Sba standards, our SBA regulations, and then we also worked with the FAR, Federal Acquisition Regulation, to make a number of changes to Part 19, which covers small business contracting in the FAR. So to start with, I'll talk about small business Sba standards. For context, one of SBA's most important roles for the whole federal government is to set the thresholds by which businesses qualify for small business assistance. That primarily comes into play for small business contracting, but it also impacts your receipt of loans or entrepreneurial development assistance. That became a very big deal during the pandemic with SBA's payment PPP. So over the past 5 years, we've been looking at our size standards to see whether they should be adjusted for the economy. And then we additionally this year in a special act, we went ahead and adjusted them for inflation given the economic circumstance. First, on the normal 5-year review that we do. Every 5 years, we look at the new census data that comes out. It comes out every 5 years for businesses to adjust size standards based on that census data. This year, or for this 5-year period, we issued 6 different batches of proposed size standards, and we finalized 4 of those batches in March of 2022. We adjusted all of the revenue-based size standards based on the most recent census data. We reviewed almost 500 size standards in this category, and we increased 230 of them. These are the size standards that, for the most part, cover a lot of the active government contracting industries. So some of the notable changes included engineering services, administrative management and consulting services, architectural services. Firms that were affected by these size standards, because this happened in March, have had the opportunity to go into SAM.gov and make adjustments to their size if the increased size standard changed their status for government contracting. As with the last 5-year review, for this 5-year review, we decided not to decrease any size standards, even though in some of these industries, the census data showed that size standards could potentially be decreased. We decided not to go ahead with any decreases because when we started this process, we were in the middle of, or as we were getting into the process of putting the rules out, we were in the middle of the pandemic, and we'd want to pull small business assistance, especially that important loan assistance, out from under small businesses that were suffering during the pandemic. Then following up on that adjustment for the census data, we adjusted all the size standards for inflation. I think it was about 14% adjustment for those revenue-based size standards because of inflation that had happened just within the past 3 years, I believe, so that businesses could remain small even if their receipts had just increased based on the recent inflationary pressures. Additionally, every 5 years, we have to reorganize our size standards around the NAICS table. And so businesses that are going into SAM.gov, I think software was one big one that was affected by this change, have noticed that SAM.gov has adopted the new North American Industrial Classification System for 2022. This actually came out from Census and the White House January 1st of 2022, but we decided not to make the change in the middle of the fiscal year. So officially, this was put into place October 1st, 2022. I think SAM.gov adjusted about a month later to put those new NAICS codes in. And those new NAICS codes that OMB and Census issued now have size standards that are associated with them. Those are active in SAM.gov along with the inflation adjustment. I should mention that with that inflation adjustment for size standards, SBA also adjusted some of the thresholds that we use for our 8A business development program. That's the program that's targeted at businesses owned and controlled by socially and economically disadvantaged individuals. Very powerful program. It's a 9-year program. If you're in that 8A program, you can get sole source contracts from the federal government, or you can get special set-aside competitive contracts where you're competing only against other 8A firms. We're also in the process of creating special advantages for 8A firms on the GSA schedule. So that's something to look out for as an additional benefit for the 8A program. With the inflation adjustment, we raised the thresholds on what it means to be economically disadvantaged for the 8A program, as well as for the women-owned small business program, as well as for being defined as a disadvantaged business. The threshold for net worth used to be $750,000, and with inflation, we increased that to $850,000. The threshold for gross income used to be $350,000 annual gross income adjusted, and that's gone up to $400,000. Total assets increased from $6 million to $6.5 million. So we made it easier for people who are seeking admission into the 8A program to qualify as economically disadvantaged for the purpose of that program. Finally, to wrap up size standards, remember we have 2 types of size standards within SBA. We don't mix them. It's one or the other. You're either based on, you're either looking at a revenue-based size standard or an employee-based size standard. We adjusted all of the revenue-based ones in March of 2022. We're about to come out with adjustments to the employee-based size standards, I'd say maybe in the next 2 or 3 months once we go through an interagency process with other agencies. So take a look out for the increases that we finalize on the employee-based size standards. We'll go to the next slide, Bill. So outside of size standards, we've also had a busy time in terms of regulation within our certification programs. David and Matt will be going over some other regulatory changes as well as case law. But one big thing that just happened earlier this week, just this week, Monday, January 9th, SBA started a brand new certification program for the federal government. We are happy to announce that we had a successful launch for the Veterans Business Certification on Monday, January 9th. For the first time, businesses can come to the federal government to get certified as a veteran-owned, actually a service-disabled veteran-owned small business for the purposes of government-wide federal contracting, or a veteran-owned small business for the purpose of contracting with the Department of Veterans Affairs. Previously, certifications were done by the VA, Department of Veterans Affairs, for contracting only with the VA. Now this is a government-wide certification program where businesses come to SBA and receive recognition for contracting with any agency, including the Department of Defense, as a service-disabled veteran-owned small business. Eventually what will happen is, in order to win a set-aside contract for firms owned by service-disabled veteran-owned businesses, you have to have gotten certification from SBA. So we saw a few hundred firms come in on that very first day on Monday to try to apply for that certification. Good to try to get in early. You don't have to, though, because the law allows for firms to get a 1-year grace period to apply. So you have until December 31st, 2023 to apply to this program before you're shut out of those set-aside opportunities. Additionally, firms have already received their VA certification get a 1-year extension for their certification. So they don't have to necessarily come back to SBA to get a renewal. Effective January 1st, 2024, though, you will have to have had that either the VA certification, the SBA certification, or show that you've submitted your application to SBA, and you can only get your award if you've gotten the SBA certification. Just like with our other programs, you need to be a small business. What we've said here is you can be a small business in any of your NAICS codes. These NAICS codes range, or the size standards range on the revenue side from about $9 million all the way up to about $45 million. So you have to be small for one of the industries that you participate in. You also have to be owned and controlled by one or more service-disabled veterans. Now, we've said for quite some time, and there's a good amount of case law, that the service-disabled veteran has to have control over all aspects of the business. But we did say here that there can be non-veterans in the running of the business that have some say over control aspects. We said one thing is non-veterans can have a reasonable right of first refusal on certain aspects of running of the business. And all of that is available in SBA's regulations if you want to see whether your management agreement or your bylaws comply with the control provisions in SBA's new certification program. Now, one aspect that came up when we went out for public comment is SBA going to keep self-certification for subcontracting? If you're a prime contractor with the federal government, if you're not a small business, so you're medium or large business, you have a subcontracting plan that requires you to subcontract a certain percentage of your contract to service-disabled veteran-owned firms. The question is, do those prime contractors have to find only certified firms? Different story for the VA, but government-wide, SBA decided to keep self-certification for subcontracting. We said we might look at that in the future, but for now, we're going to keep self-certification. Next slide, Bill. So I do want to go over one regulatory change that SBA made in the middle of 2022. We came out with a final rule that had been in place we've been working on for almost 4 or 5 years to allow small businesses to get past performance, not just for working as a prime contractor, but also from joint ventures or as first-tier subcontractors. Joint ventures is pretty straightforward. If the small business is part of a joint venture, it just tells the contracting officer, I was part of this joint venture, give them their UEI, and the contracting officer can look that up in CPARS. First-year subcontractor is a little more complicated. We didn't want to give access to CPARs for businesses. CPARs is the past performance rating system that the government uses. So what we said is the small business can make a request to its prime contractor. It has to be a first-level subcontractor. It can make a request to the prime contractor for a rating that prime can then respond within 15 days of the request, or it must respond within 15 days of request. And then that small business can use that response, turn around and give it to the agency to act as the past performance rating for that subcontractor the small business did. There is a time limit for the small business to make that request. It has to make that request within 30 days of the end of the period of performance. You can make it during the contract. We did say that in the rule, but there's a shut-off point at which the small business can no longer make that request. Next slide. So just very quickly, I did want to say that the FAR has been busy as well for in adjusting the small business rules in Part 19. 4 actions just at the end of last year, or the end of the fiscal year of in September 2022, the FAR came out with 4 small business rules. One of them recognized women-owned small business certification. That means that will be showing up in SAM.gov shortly. Right now, what you see in SAM.gov is a self-certification for women-owned small business. For a couple of years, SBA has been certifying women-owned small businesses. So because of this FAR rule, once the FAR moves, SAM.gov can adjust, and SAM.gov will be showing the women-owned small business certification. The FAR also recognized in the HubZone program that SBA has started to certify HubZone firms for a full year. It used to be you had to, as a historically unutilized business zone firm, you had to attest with every contract that you meet SBA's requirements. That's having your location in a historically underutilized business zone and having 35% of your employees reside in historically underutilized business zone. Easy for me to say. The requirement now is you have to be qualified at one point in time per year at your anniversary date, and then you're good for the whole year. So the FAR recognized that adjustment in SBA's regulations. The FAR also allowed SAM.gov to start asking for information about joint ventures. So very soon in SAM, maybe within the next few months, if you're a joint venture, you'll have to state who the members of your joint venture are so that the agency can perform analysis based on the members of your joint venture. And then finally, there was a provision to make it more transparent to small businesses on how quickly agencies definitize requests for equitable adjustment in construction contracts. So that transparency should start showing up in contracts fairly soon. So one last thing is there will be a change soon to the SDB net worth threshold. That's the 750 to 850,000 change. The FAR is working on that now. So with that, I'm going to turn it over now to Matt Carter to go over some legislation. He's a partner with Pillsbury Winthrop.
Thanks so much, Sam. Again, as Sam just mentioned, my name is Matt Carter. I'm a partner at the law firm Pillsbury Winthrop Shaw Pittman, and I'm going to turn now to some important developments on the legislative side impacting small businesses. And first up is the Small Business Innovation Research and Small Business Technology Transfer Extension Act of 2022. Now, as many of you likely know, these programs were set to lapse on September 30, 2022. Now, thankfully, Congress stepped in at the last minute, issued this extension act, which extended the programs through September 30, 2025. Now, in addition to extending these programs, the act included several new requirements focused on potential national security risks associated with these programs, as well as some new requirements addressing concerns relating to serial or multiple award winners under these programs. So starting now with some of those requirements focused on national security. Under the Act, agencies are now going to be required to establish a due diligence program to assess the potential national security risks presented by small business concerns who receive awards under these programs. Among other things, agencies will now be directed to scrutinize the small business concerns, cybersecurity practices, their patents, and any ties or obligations to foreign actors. In addition, small business concerns are now going to have an obligation to disclose any ties to certain foreign countries and certain foreign actors, such as the People's Republic of China, Iran, Russia, North Korea, etc. Now, if it is determined that a small business concern has made a material misstatement concerning its ownership structure or its connection and ties to these foreign actors, such small business concern would be forced to repay any funds received under the program. And in addition, that those types of misstatements could subject them to civil or criminal liability. In addition, there's an ongoing disclosure requirement if there's a change in ownership of the small business concern, and if a change happens that the government determines poses a risk to national security, again, the small business could be directed to repay any funds received under the programs. Next slide, please, Bill. In addition, sticking with the same national security risk theme, there's another requirement for certain agencies, specifically the Department of Defense, Department of Energy, Department of Health and Human Services, and the National Science Foundation, to submit a report assessing adversarial military and foreign influences in the program. So we'll have to stay tuned to the findings in these reports, as those findings could impact these important programs on a going forward basis. Now, shifting from the new requirements on national security risks, there are also several requirements trying to get to the issue of multiple award winners under this program. There's been a problem over the years with certain small businesses who appear to rack up award after award, but don't appear to move from phase 1 to phase 2, or don't appear to actually commercialize their technology. So because of that, this act requires agencies to increase the minimum performance standards for small business concerns with more than 50 phase 1 awards in the past 5 years. And if these small business concerns, these serial awardees, fail to meet or satisfy these increased standards, they will not be eligible to receive more than 20 total phase 1 or phase 2 awards from each agency for a 1-year period. In addition, the Act requires the GAO to conduct a study on these multiple award winners and to study their impact on the programs as a whole. I expect these reports to look at whether these serial awardees are receiving phase 2 awards, whether they're able to, in fact, commercialize their technology, and really what is their impact on other small businesses trying to compete for these important awards in these programs. In addition, the Act requires the GAO to submit a report on subcontracting in these programs. And the goal here is to assess the extent to which subcontracts are being awarded to other than small businesses, so to large businesses, which would be inconsistent with the goal of both of these programs. Next slide, please, Bill. The final point I wanted to highlight here with this act is a requirement for DoD to establish what are referred to as innovation open topics under these programs. Now, historically, most of the topics posted under these programs are conventional topics. Essentially, DoD goes to industry and says, we have this need, we're looking to develop this technology or a solution to a certain problem, and allows industry to submit proposals. On innovation open topics, in contrast, it allows industry to go to DoD and say, we have this idea, we think this technology could be used in this way to benefit DoD. So under this act, there's a new requirement for each DoD component to release at least one open activity announcement each fiscal year. And the goal here is to increase the transition of commercial technology to DoD, expand the small business, non-traditional industrial base, and to increase commercialization derived from DoD's investments. Next slide, please, Bill. Now I'm going to shift to the National Defense Authorization Act for fiscal year 2023. Now, when we were preparing these slides, the bill had not been signed into law by the president, but subsequent to our preparation of the slides, President Biden signed the NDA into law. So let's focus now on how this impacts small businesses. Well, first, the NDA codifies the DoD Mentor Protege Program and establishes a separate Department of Homeland Security Mentor Protege Program. Now, as it relates to the DoD program, it increases program participation from 2 years to 3 years, and also reduces the mentor eligibility threshold from $100 million in DoD contracts and subcontracts in the prior year to a much lower threshold of only $25 million. The NDA also codifies the SBA scorecard into the Small Business Act. Now, for those of you who are unfamiliar, the SBA scorecard is a tool that's used to assess how well agencies are doing and reaching their small business and socioeconomic participation, prime contracting and subcontracting goals. And the NDA also expands the agency's scorecard reporting requirements to include information on awards made to concerns and the service disabled veteran-owned small business, hub zone, woman-owned small business, and 8A programs. In addition, the NDA requires reporting on consolidated and bundled contracts. Now, there's been a concern historically that the consolidation and bundling of contracts has a disproportionate impact on small businesses and removes opportunities for small businesses to compete for government contract awards. So now, in light of the NDA change, agencies will be required to provide information identifying the impact of any bundled or consolidated contracts. In addition, the NDA also establishes a small business integration working group within DoD. Now, many of you on this call may have experienced a situation when you're working with two different agencies within DoD where sometimes it may feel like the right hand doesn't know what the left hand is doing. Now, this group is put in place to help ensure that there's some integration and synchronization among the various components of DoD with respect to small business concerns. The NDA also establishes a program to help small businesses guard against malicious foreign actors. This is in recognition of the fact that small businesses don't have the same type of resources that large businesses have. So this program is being stood up to help identify certain commercial tools, techniques, and practices and processes that small businesses can use to identify attempts by malicious foreign actors to infiltrate their business and their technology. And importantly, this program will ensure that training is provided to small businesses on these various tools, techniques, and processes. Now, for some of you who have been following prior versions of the NDAA, at one time there was a provision that was going to raise the sole source threshold from $3 million to $8 million and from $7 million to $10 million for manufacturing contracts. That provision did not make it through to the final version, so we'll have to stay tuned to see if that comes through next year. In addition, there was in an earlier version a provision that would provide firms in the 8A program the opportunity to stay in the program for an additional year. Unfortunately, that provision did not make it through to the final version. Next slide, please, Bill. Now, the final point I want to cover in the NDAA section of this presentation deals with something that's impacted us all in the past year, and this deals with inflation. We've heard time and time again from our clients and time again at different small business trade groups and industry presentations about the significant impact that inflation has had on all of your business. Well, Congress listened, Congress heard you, and in the NDAA, they have now provided the Department of Defense authority to provide adjustments to help you out as a result of the significant impacts from inflation. Now, again, this only applies to DoD contractors, but the NDA allows either the prime contractor or the subcontractor to submit any requests for price adjustments. Now, importantly, the Act makes clear that DoD cannot seek any type of consideration for this type of price adjustment. Now, once funds are appropriated to allow for these modifications and price adjustments, DoD will have 90 days to issue guidance on how the process will work and how DoD will determine whether or not to process the request. So stay tuned for developments on that front. And final point here is that this relief is temporary. It's only authorized through the end of 2023. Now, I guess before we go to the next slide, Bill has a poll question.
Yes, if you're interested in CLEs for this session, please respond to our poll, yes or no. and we'll keep track of that, and we'll be able to verify your attendance when we are approved. We're going to leave this poll up for about 2 minutes, and I'll let Matt continue, and thank you so much.
Great, thanks, Bill. Next slide, please. So now we're going to shift back to a proposed regulation. And I typically wouldn't talk about a proposed rule, but this proposed rule is of very high significance. It's gotten national media attention, and I want to make sure that you're all aware of the requirements under the proposed rule and the significant implications if this rule gets passed. Now, this proposed rule would require federal contractors to make disclosures and representations regarding their greenhouse gas emissions. Now, this would apply both to major and significant contractors. So what does that mean? Well, a major contractor is an entity other than a small business that received more than $50 million in federal contract obligations in the prior fiscal year. But a significant contractor is defined as an entity that has received $7.5 million or more, but less than $50 million in federal contract obligations in the prior fiscal year. Now, the proposed rule itself notes that this could cover almost 3,000 small businesses that received federal awards in the prior year. So it could impact many of you listening to this presentation today. So what does the rule actually require you to do? Well, first, it requires you to certify on SAM whether you qualify as a major or significant contractor, and then whether you're in compliance with the requirements of the rule itself. So next slide, please. Okay, so what does this rule require? Well, it requires both major and significant contractors to prepare an annual greenhouse gas inventory of Scope 1 and Scope 2 greenhouse gas emissions. So Scope 1 emissions, these are direct emissions from sources that you directly own or control. So think about manufacturing process and emissions associated with that at your facility, but it also could cover any emissions from vehicles that you own or control. Scope 2 emissions, on the other hand, are indirect emissions from facilities and sources regarding electricity, heat, steam that you use in your organization. So think emissions generated from your utility provider. And so this rule would require you to disclose your GHG inventory on SAM. Now, taking a step back, this seems tremendously burdensome and complicated, not only for major contractors, the Lockheed Martins, the Boeings of the world, but particularly for small businesses who don't have compliance staffs and who certainly most likely do not have anybody who understands how to calculate greenhouse gas emissions. So this is going to create tremendous burdens and administrative resources for any small business contractor that qualifies, which according to the proposed rule is about 65% of all small businesses that received awards in the prior year. So next slide, please. So I've highlighted here some additional requirements that will be imposed on major contractors. Now, this is kind of outside the scope of our conversation today, but in addition to Scope 1 and Scope 2, they'll be required to report on Scope 3 emissions, which include emissions coming from the supply chain. And next slide, please. And in addition, the major contractors also have to develop science-based targets to reduce their emissions in accordance with the Paris Climate Agreement. And I raise these only because we know at some point, if this rule goes into effect, these requirements imposed on major contractors could someday be applied to significant contractors. In other words, could be applied to small businesses. So it's important to be aware of this. This could create significant administrative burdens for anybody having to comply. Now, in addition, the most important thing to keep in mind is that failure to comply with this new rule could result in you being found non-responsible and thus ineligible for awards. Now, even worse, we just talked about how hard and difficult it may be to make these calculations and finding someone with the appropriate expertise. But of course, if you make certifications and statements on SAM regarding your GHG inventory and the scope 1 and 2 emissions, you could be subjected to civil or criminal liability for false statements or false certifications. And those, of course, could also have implications for suspension and debarment. So comments are due on this proposed rule on February 13th. I know I'm currently assisting clients provide comments on this rule. Many industry trade groups will be doing the same. So I encourage you to provide any comments you have on this rule, as it's going to have significant impact on your business. Next slide, please. So now I'm going to shift from legislative and regulatory developments to highlighting 2 cases from the Court of Federal Claims that may impact you and your business. The first case is a case called E&L Construction, and this dealt with the unconditional ownership requirements for service-disabled veteran-owned small businesses. And what it really dealt with was something that was referred to as the Wexford Standard. And this was a standard developed under the case law that said to qualify as a service-disabled veteran-owned small business, there could be no conditions or limitations upon the service-disabled veteran owners a present or immediate right to exercise their full control and ownership of the business. Essentially, the courts have said that service-disabled veterans must immediately have an absolute right to do anything they want with their ownership interest and be able to do so whenever they want. Well, in 2018, the SBA amended the definition for conditional ownership by adding exceptions, and exceptions for death, for incapacity, and also for pledges of stock as collateral if the terms followed normal commercial practices. So the issue in this case that was posed to the court was, did the Wexford Standard survive the 2018 amendments? And did the normal commercial practices language in the exception, did it apply to all terms of an owner's ownership agreement and business documents, or was it only related to pledges of stock? Next slide, please. Well, the court first held that the SBA did not abandon the Wexford Standard when it amended the regulations in 2018. The court then clarified the issue concerning the normal commercial practices language. And the court said that that exception is limited to pledges or encumbrances of an ownership interest and cannot be used to determine whether any other type of provision renders an individual's ownership conditional. Now, I raise this because, as Sam mentioned earlier, with these significant changes to certification, moving away from self-certification rules, service-disabled veteran-owned small businesses really need to closely review their ownership and control documents to ensure their compliance and to ensure that they continue to use those important designations. Next slide, please. Final case I wanted to highlight was a very fascinating case called Focus Revision Partners. And in this case, Focus Revision Partners filed a size protest, but their size protest contained an error. It incorrectly stated that Focus Revision Partners JV LLC was the protester, not Focus Revision Partners. So they added that JV LLC language incorrectly. So the area office of the SBA denied the protest, and Focus Revision Partners filed an appeal with the Small Business Office of Hearings and Appeal. Well, on appeal, the challenge concern identified this clerical error and filed a motion to dismiss. They said no party named Focus Revision Partner JV LLC submitted a proposal, so that entity did not have standing to file a size appeal. Well, Focus Revision Partners responded and filed a motion to amend its pleading. They said, yes, this is just a clerical mistake. We'll clean that right up. We should proceed forward with the appeal. Well, OHA disagreed, the Office of Hearings and Appeal, and they granted the motion to dismiss and denied Focus Revision Partners' motion to amend its pleading just to correct that single clerical error. Well, Focus Revision Partners thought that was unfair and sought review at the Court of Federal Claims. Next slide, please. And they could not have received a better draw in terms of their case assignment, as Judge Solemson was assigned to their case. And Judge Solemson overturned the SBA's ruling and said that the SBA improperly transferred a mere clerical error into a fatal jurisdictional defect. Judge Solemson said, for the court to endorse that decision would defy common sense and glorify a semantical distinction to promote form over substance and academics over common sense. Really what he said was, that's not fair. We need to do what's right, what's just. Nobody had any question about who was filing the size protest or the appeal. There was no prejudice to any of the parties related to that obvious clerical error. And so for that reason, Judge Solemson overturned the SBA's ruling. And so the key takeaway here is, for those of you who find yourself in a position where you need to file a size or status protest, you really need to proofread your pleadings to guard against these types of errors that could lead to headaches in terms of litigation. But also, don't forget about your right to seek review of an unfavorable or unfair Office of Hearings and Appeal ruling at the Court of Federal Claims. And with that, I'm going to turn it over to David.
All right, thank you, Matt. I'm going to be covering OHA decisions last year. It was a busy year for OHA. Basically, what you're going to see is in 2020, there's a really significant final rule that made a lot of adjustments to certifications related to multiple award contracts, joint ventures, and we're seeing decisions come through the protest system in 2022, interpreting and applying that. And some of the decisions, I think, were really quite surprising and very interesting. So we're going to start with unrestricted IDIQ contracts. And in 2020, before 2020, the rule was for an unrestricted IDIQ contract. That's one where it's not a set aside. Both small businesses and larges could compete and get on the vehicle. And of course, small businesses represent their size at the time of proposal. That before 2020 was their status for the life of the contract. And task orders, when task orders were set aside under an unrestricted IDIQ contract, they could rely on their size at the contract level. In 2020, SBA amended that and said, going forward, for unrestricted IDIQ contracts, it's going to be required for set-aside task orders to represent the size at the time of the task order. And of course, that's important because small businesses that grew from the time of the base contract award to the time of a future task order may not be eligible if they're forced to certify. Now, the question was, okay, what about all these existing IDIQ contracts, unrestricted IDIQ contracts? Does this rule apply to those? There was a 2012 OHA decision where OHA said, you know, when you're making a size representation at the task order level, we apply the regulations that were in effect when the base contract was solicited. And so I think a lot of folks thought that this new regulation was going to take some time, that existing unrestricted IDIQ contracts would effectively be grandfathered, that the task order size certification really wouldn't apply until they were replaced with future contracts that were competed under the 2020. But OHA had some surprises for us. Next slide. And so when looking at, you know, whether regulation applies, you know, retroactively or prospectively, you know, the Federal Circuit has said that a regulatory amendment creates a new obligation or imposes a new duty or attaches a new disability, doesn't apply retroactively to existing contracts. And so that really is one of the questions, is having to make a size representation at the task order level, is that a new obligation, new duty, or new disability? And that was really the issue in Avenge Incorporated. It involved an unrestricted contract awarded in 2015. It involved a task order that was solicited in June 2021 after the 2020 amendment. Does the rule apply? Next slide. And I think OHA somewhat surprisingly said it did. They didn't really deal with their Tyler decision. They didn't really deal with the Federal Circuit. They basically looked at what was SBA's intention, and they said SBA intended to close this loophole. And so we're going to apply the regulations in effect at the time of the size certification, whether it's at the task order level or the base contract level. In this case, it's a task order size certification in 2021. So the regulations in effect in 2021 apply. And so the small businesses under unrestricted IDIQ contracts are required to certify. There is no grandfather. So I think the key here is folks need to pay attention to this. They may think they're able to rely on their size at the base contract level, when in fact they are required to make a size representation for every task order that's set aside. Next slide. Now, this next case involves another part of the 2020 rule that applies to joint ventures. And when does a joint venture's activities create affiliation? Before 2020, it was the 3 and 2 rule. The JV, as long as it didn't get 3 contract awards within a 2-year period, it could stay in existence and continue bidding. In November 2020, SBA changed it to a 2-year bidding period, where from the date that the JV, it could receive an unlimited number of contract awards made within 2 years of its first award. And so it could bid for as many contracts, it could receive more than 3, but after that 2-year bidding period, if it submits a bid, it's affiliated, the 2 joint venture members are affiliated for size purposes. And so the question is, well, what about JVs that were formed before November 2020? And this is, in my opinion, a jaw-dropping case. Next slide. So again, this case involved a member to a joint venture called Optimal Geo, and it was bidding on a set-aside. And it was small, as long as it wasn't affiliated with its joint venture partner. And the facts here were it was a 50% owner of a small business joint venture formed in 2016. It did not violate the 3 contracts in 2 years rule that applied, but it did keep bidding on contracts after a 2-year bidding period. Now, of course, the thing here is the 2-year bidding period didn't come into effect until 2020, but it submitted a task order proposal in January 2021. That was the date of the size determination. And the question was, is it affiliated with its joint venture partner or not? Next slide. And OHA surprisingly said that it was. It said that, well, we're applying the regulations in effect at the time of this size certification, and this January 2021. And so we judge the bidding activities of the joint venture based on these rules. So the joint venture in 2019 submitted a proposal outside the 2-year bidding period. So therefore, it violated the rule in 2019, even though the rule wasn't in effect. And therefore, sorry, Optimal Geo, you are a large business. So it's a really, to me, this is a stunning decision. I think there are probably a lot of joint ventures from the teens that weren't successful enough to get 3 awards in 2 years, so they kept bidding outside a 2-year period. That is a lot of potential exposure, and it's fodder for size protests. Something to keep in mind when you're going on the offensive, looking at the activities of a small business that's recently won a set-aside. Next slide. To 2 decisions that deal clarifying the rules regarding unrestricted multiple award contracts, and then we'll get into a federal supply schedule rule. And these are really helpful. The first case sort of dealt with the interplay, again, 2 aspects of the 2020 rulemaking. They kept the rule intact that for an unrestricted multiple award contract, size is determined at the time the contract is awarded, and that's good for the life of the contract. And unless the contracting officer asks for a task order specific representation, small businesses can rely on their contract level size representation. There was another rule, part of the 2020 rulemaking that dealt with what happens when there's an M&A transaction in between the time a proposal is submitted and the time award is made. And the rule basically said that if you do M&A and you're large after the transaction, you've got to tell the contracting officer, and if award has not been made, and so the question is, well, what happens for task orders under restricted IDIQ contracts? Next slide. Basically, the facts were just that the protest to concern had the OASIS small business pool, restricted IDIQ. They submitted a task order proposal in January 19th, 2021. In February, they announced that they're large, they've merged, and award isn't made until April. Next slide. And here OHA said, you know what, for restricted IDIQs, we intend to keep that rule intact. And so this rule that deals with the M&A in between proposal and award does not apply to restricted IDIQs. And that's the way OHA came out on that. So that's helpful for those types of contracts. Next slide. And I've got about 5 minutes of material left. I know we're at time. Alan, is it okay if I go 5 minutes over, or how do you want to proceed? I want to be respectful.
Because we do have to transition. Thank you. 3 minutes.
Okay. 3 minutes. Okay. Thank you very much. For federal supply schedule, in 2020, the rulemaking exempted federal supply schedules from the rule on unrestricted IDIQ contracts. And this is a case that shows that that meant exactly what it said, that for, in this case, next slide, this was a federal supply schedule set aside task order. The company was large at the time of task order because of M&A activity, but it was small at the time, you know, at the FSS contract level. And it was held that it could rely on its, even though the FSS is an unrestricted type of IDIQ contract, it could still use its contract level size status because federal supply schedule contracts were exempted from the 2020 rulemaking. Next slide. Then, and next slide. Then just interesting cases on JV requirements. I'll let you read the slides here, but basically there's a lot of size protests that are sustained because people aren't dotting the I's, crossing the T's on their joint venture agreements. People aren't complying with the list of requirements for those agreements here. The facilities and personnel weren't specified. Next slide. In this case, Syscom, there was no actual operating agreement, and so they did not specify that the protege was the managing member. And so they were found to be ineligible. Next slide. This is a really interesting case for the SBIR program. Basically, I will summarize the holding, which is on the next slide, that the affiliation rules in the SBIR regulation, 13 CFR 121.702, it's clear they applied to making the 500 employee size determination. But OHA said we also use those to determine whether you can comply with the ownership and the U.S. ownership and control requirement. And in this case, the SBIR company, even though it was 51% owned by a U.S. individual, it violated the ostensible subcontractor rule, which is, you know, converts it into a joint venture, and its subcontractor was a foreign-owned company. And the rule in the SBIR statute is all members who a joint venture have to be comply with the U.S. ownership and control requirement. Really surprising result. The interesting tidbit here about the newly organized concern rule as well. So I really commend that to reading if you are dealing with SBIR companies. And then the last case, next slide, and next slide, is a really cool due process case. If you get a size protest decision from the area office and it cites a ground for affiliation that you weren't given an opportunity to address, OHA says that's unfair, that violates due process. It will kick it back to the area office to give you an opportunity to respond. Next slide. And that's the C2 Alaska case, very interesting case. Thank you, Alan.
David, thank you. I apologize for the time squeeze, but there's so much information, and just a great job from Sam, Matt, David. Lots of great questions were posed. Some of them are going to require law review articles to respond to, but we'll get to them as best we can. So thanks again to the panel members. Let me again thank our event sponsors for their support on these next two slides. Thanks, and enjoy the rest of the day.